regardless of whether you're in the car or on a plane, it's $450 an hour, correct?
Yes, sir.
And you have traveled and testified in other states, is that not correct?
Yes, sir.
I believe you've testified in Ohio, for instance,
Yes, sir.
Louisiana and Kansas,
Yes, sir.
Missouri and Tennessee,
Yes, sir.
Nebraska and Texas,
Yes, sir.
and finally Illinois.
Yes, sir.
And admittedly, I don't have the most up-to-date records, but in 2009 I was able to get your invoice records. Would it sound appropriate to you or correct that you were able to earn about $150,000 from the Missouri Public Defender down there in your consultations, at least for that year?
Sounds right.
And that doesn't deviate too much from your general practice in terms of invoices for criminal cases, does it?
I don't understand the question.
Sure. You typically work for criminal defense attorneys in the criminal area, correct?
Yes, sir.
And at least that accounting of your invoices, that was not an unusually good year for you, was it? 2009 wasn't like ridiculously high for your invoices and the salary?
I don't recall.
As far as year to year, you've mostly consulted in, for at least criminal cases, for defense attorneys, correct?
Fair. Yes.
And going to the publication you had in August 12, 2007, I believe it was called Catch 22 No More, 22 Lessons Learned as a Chief Medical Examiner, is that correct?
Yes, sir.
And you wrote that book?
I did.
Now, Lesson 1 was entitled Always Be Willing to Leave Your Job, correct?
Yes, sir.
Lesson 4, Demand Good Salaries, correct?
Yes, sir.
And in Lesson 4, you actually noted, like it or not, money equals appreciation and accurately predicts human behavior, correct?
It does.
And essentially you're advocating that high money equals high appreciation and low money equals no appreciation, correct?
Yes, sir.
And then in Lesson 6 you stated, if you agree to do private work, do not give it away cheaply, demand a high amount of money. After all, money equals appreciation and you should get all the appreciation you deserve.
Fair.
And through the course of your activities as a forensic pathologist, I'm sure you're familiar with Spitz and Fisher's medical legal investigation of death, correct?
Yes, sir.
That is actually kind of one of the textbooks I think you were alluding to in your direct testimony.
Yes, sir.
And that's a pretty foundational textbook in the area of pathology.
What do you mean by foundational?
When someone lists seminal works, textbooks, educational materials relating to pathology, Spitz and Fisher would usually be amongst those lists, correct?
Fair.
Now, as far as familiarity, I presume, since you noted comparisons to the literature, that you're familiar with the chapter on asphyxiation, strangulations, hangings, those types of deaths?
Sure.
And at least during your testimony on direct, you essentially noted, for purposes of Cavalier's claim as to the loss of consciousness of this child being quick, that there is no scientific literature backing her claim.
Okay, I don't recall talking about how quickly the child lost consciousness.
During direct, were you not asked as to her assertion that this child likely lost consciousness quickly, that there was no scientific literature to back that assertion?
I don't recall that question.
You noted she was just making an assumption in that area?
I don't recall that question.
Now, as far as the medical legal investigation of death, does it not note that the amount of pressure on the neck that can bring about loss of consciousness is remarkably low?
Okay. Repeat the question, please.
Sure. Spitz and Fisher's medical legal investigation of death, at least in much like most literature, does it not note that the amount of pressure on the neck is that is necessary for loss of consciousness is remarkably low?
That's fair.
And you only need 5 or 6 pounds of pressure on the carotid arteries and jugular to cause loss of consciousness.
That's fair too.
And then they note 32 pounds is required to block the airway.
I thought it was less than that. I thought it was more like 11 pounds.
So not much at all, essentially, though.
Fair.
And then, at least in Spitz and Fisher and other literature, that relies on it, isn't it consistent with that literature that at least the subtle loss of consciousness accounts for a large number of accidental hangings, especially in children?
Okay, repeat the question again.
Sure. Is it not correct that most literature, for instance, Spitz and Fisher's textbook, notes that a subtle and insidious loss of consciousness accounts for a large number of accidental hangings, particularly in children?
That's fair.
And then it goes on in terms of surveys that have been done of hangings, that judging by the circumstances under which these individuals are found, there is certainly no indication that this is a traumatic, painful way to die. Is that correct?
You mean a hanging death?
Yes.
That could be a fair statement.
And then, at least as the hanging does, just to couch that, a review of all relevant facts suggests that most hangings, whether accidents or suicides, cause a subtle and painless death.
I don't know about the painless. Usually people who do this sort of thing don't live to tell about it. But I don't know what else to say. People do hang themselves. And there are certain assumptions that are being made even in those particular items there, because nobody really lives to tell about their experience necessarily. Loss of consciousness is pretty quick in that sort of situation. If you're blocking the arterial circulation of the brain, you can lose consciousness very quickly.
And at least in most fairness to Spitz and Fisher, loss of consciousness would indicate the person isn't sensing pain, at least in how we define consciousness.
Sounds fair?
Now, doesn't Spitz and Fisher also note that at least with hanging, when a twisted piece of clothing or a soft blanket is used, there may be no mark at all on the skin?
There may be no mark.
And then, later on, it notes hanging may occur without possible visible marks. A loop of soft fabric, such as a towel or scarf, may cause no noticeable injury.
That may happen.
And then blankets or sheets used for hanging are often left whole or ripped into strips and sometimes braided to make a noose. But if left whole, there may be little to no damage to the skin because of the width and smoothness of the fabric.
That's fair. There may be no mark.
And once again, just in terms of hanging, literature indicates that injuries to the strap muscles of the neck are rare in a hanging.
Injuries to the strap muscles?
Correct.
In a hanging, that would be true. Usually somebody deals with their own neck very gently when they're hanging themselves.
But this review also doesn't just deal with suicides, but it's a survey of accidental hangings as well, is it not?
I don't know. I don't remember. If this is from Spitz and Fisher, I don't recall what he said on that specifically.
I have the chapter available, but would you disagree if that's what's noted in Spitz and Fisher?
That's fine.
Now, as far as the tongue, when it comes to hanging, isn't it common for the tongue to protrude from the mouth in a hanging victim?
It is.
And that's just because the mechanism, I guess there's upward pressure on the neck organs, and that kind of pushes the tongue outwards.
Sure.
And then also, it's noted that deep bruises sustained in a struggle or attempted self-defense may not always be apparent in death, if death followed rapidly. Is that correct?
Perhaps.
So they recommend that incisions be made in strategic locations known to be frequently injured in order to detect such damage, correct?
Sure.
And some of those procedures would be like reflection, or in other words, why it's kind of peeling back parts of the neck to find these subtle indicators.
Sure.
And you need to keep the integrity of the body so that you don't actually create what's called an artifact, correct?
Sure.
And artifacts would just be things that essentially somebody carrying out the autopsy messed up on that causes hemorrhaging or something that isn't really part of the death, it came afterwards.
It doesn't imply that somebody's messed up. Artifacts can be made that were not present in life, but just due to the nature of doing an autopsy, they can show up and be confused with something that occurred in life.
And then also going back, did you review, in coming to your conclusions, the chapter relating to child deaths of Spitz and Fisher?
Yeah, I don't recall doing that.
At least in terms of your general knowledge of the literature, would it be appropriate to note that when it comes to children, the literature indicates that their bones haven't calcified as much as maybe an adult?
That's fair.
And that just means that there's more cartilage as opposed to bone. Sorry for not using the proper term, but in a child versus an adult.
Well, I don't know that you can draw that conclusion. A bone is a bone.
And by that I just mean there's less calcification in a child, in a child than an adult in terms of their bones.
That's fair.
As far as the hyoid bone specifically, until the age of about 30, it has two halves that don't fuse till that age, correct?
Well, there may be portions of the hyoid bone that never fuse even after the age of 30.
But there are two specifically large halves that tend to, correct?
Okay, hyoid bones are very, very different in everybody. Some basically will have one particular item. Some will have a false joint on one side. Some will have two false joints, making anywhere from 1, 2 to 3 different portions on a hyoid bone. And usually these are joints, so they don't necessarily fuse, even in an older person.
Now, once they have fused, the likelihood of them breaking increases, correct? At least during a hanging, strangulation, those types of things.
I don't know that.
Now, going to your experience, you noted that you had never come to the conclusion or made a finding of a child hanging or strangulation, correct?
Correct.
And I believe even hanging is fairly rare, particularly just in the literature and whatnot.
Well, hanging deaths in children are unusual.
I believe, at least in a review of your work, you had noted one child that you had done the autopsy of that died of a leather ligature hanging.
Yeah, I recall one case where the child ended up using a belt and hanging from the bunk bed, the upper post.
And that would have been the one hanging child death that you have done an autopsy of?
At least, yeah.
Just generally, you're familiar with the 2009 federal government's report labeled Strengthening Forensic Science in the United States, correct?
Yes.
You've actually, I think, referenced it as recently as 2019 in an interview.
Yes.
And essentially, that report was created due to some issues that had come up in forensic science.
Yes.
I think there was an issue of a fingerprint being tracked from Spain to someone who had never been to Spain, and so a prosecution had come from that, correct?
Yeah, that's the Brandon Mayfield case.
And those 2009, that report, it had a list of recommendations, did it not?
Sure.
And you even know that, unfortunately, forensic pathology hasn't come along as far as it should compared to other sciences, just because these types of rigors weren't applied or hadn't been applied.
Okay, is that something I said?
To that effect, would you like to review the interview just to get the exact wording, or is that kind of a general gist?
Okay, I don't recall it.
Is that a general gist, though, that you would agree with?
Okay, once again, it's that forensic pathology didn't do what?
as a whole in this country hasn't come as far as maybe other sciences in terms of reliability, partly due to issues that are identified in the 2009 report and lacking the application of that 2009 report's recommendations.
I don't remember saying that, but maybe that's the case.
Now, you're also a part of the American Academy of Forensic Sciences,
Yes, sir.
and you're aware that the recommendations from that 2009 federal report, they were adopted by the board of directors of that academy.
Okay, I don't recall what the American Academy of Forensic Sciences did officially in regard to that 2009 Strengthening Forensic Science in the United States report. They talked about it a lot.
Are you familiar with the general recommendation, would be recommendation 1 for Congress to set up an advisory board for the forensic science disciplines?
Yes?
I think the National Commission for Forensic Science is what they ended up coming up with, is that correct?
Well, they've had several things. During the Obama administration, they also had the Organization of Scientific Area Committees, the OSAC, where they set up different kinds of groups and committees to talk about different areas of forensic science.
And then recommendation 9 was a recommendation for a national code of ethics, correct?
Okay, I don't recall.
And that was actually, I was coming from the National Commission. Would that jog your memory?
Well, that's the organization that authored that treatise.
Since you're not as familiar with their recommended code of ethics, which hasn't been implemented by anyone, would you generally agree with some of the recommendations, such as avoiding participation in any case where there are personal, financial, or employment-related conflicts of interest?
That's fine.
And then conducting full, fair, unbiased examinations leading to independent, impartial, objective opinions and conclusions.
Okay, say that again.
Another recommendation from this code of ethics was conduct full, fair, and unbiased examinations just for objective opinion's sake.
Sounds good.
And then finally, communicate it honestly and fully once the report is issued with pretty much everybody, prosecutors, defense attorneys, all our expert witnesses, correct?
Sounds good.
Now, in lesson 4 of Catch-22, you noted some discussions of hiring. I think it was hiring investigators. Do you remember that chapter?
Sure.
And it discusses hiring competent investigators because you're only as accurate as they can be.
Sounds good.
I think the phrase garbage in, garbage out comes into play, correct?
Sure.
And then lesson 20, when you're discussing contracting outside pathologists, you noted that asking pathologists or non-pathologists lacking proper training and credentials for autopsies, that would be dangerous, correct?
Seems sure.
It could lead to essentially bad garbage coming out of the office.
Yeah, in any sort of a situation, if you're getting inaccurate factual information, inaccurate data, that will cause a whole lot of problems.
So you're only essentially as good as people that work for you.
I think in many respects that may be the case, sure.
Now, let's go back to the time you were chief medical examiner for Jackson County. That was Jackson County, Missouri.
Yes, sir.
As far as Dr. Thomas Gill, do you remember hiring that doctor?
Yes, sir.
Now, back in 2005, multiple prosecutors threatened to stop using your office due to concerns about his credibility.
Yes, sir.
And that was essentially the chief prosecutor from your county, Mike Sanders. He supported that request.
Yes, sir.
The chief county from Platte County, Eric Zand, he supported that request.
Yes, sir.
The chief prosecutor from Clay County, Cass County, and Clinton County also supported that.
Right.
All of those counties were served by your office.
The only offices that were routinely served were Platte, Clay, and Cass counties. Clinton County, very infrequently. Lafayette County, which I think was on the list there, also very infrequently.
Now, it was kind of a big thing in the media, at least down in Jackson County, it seems, correct?
What was the big thing in the media?
This request that Thomas Gill no longer be used for criminal autopsies.
The request wasn't. Issues having to do with Thomas Gill ended up being made a big splash in the media.
And you were asked about it, and at least at the time, in 2005, I believe, you noted that you stood with them even if it meant leaving your job.
Okay, what was the question again?
Sure. In 2005, after these prosecutors made the request for you not to use Thomas Gill, at least for criminal autopsies, you had stated you stood by him even if it meant leaving your job.
Sure.
And then, and this probably goes to what you're saying as to a big splash, Frontline, NPR, and ProPublica did a joint investigation of Thomas Gill, correct?
They did.
They interviewed you for that story as well.
Sure.
Now, this was because it turned out that Gill had been forced out of a teaching position back in Oregon University back in the 90s.
And he had a lot of problems, including a DUI. He had an alcohol problem, and that reflected in his work there at Oregon as a neuropathologist, and also in his work as a forensic pathologist for Marion County, Indianapolis, Indiana.
He was actually, I think, fired for being under the influence of alcohol at that job, amongst inaccurate findings as well.
Well, after the DUI arrest, he was immediately dismissed from the job. His license to practice medicine was also suspended.
Then he also was demoted for poor performance while he was at Los Angeles County Coroner's Office, correct?
Not correct. Okay. He was asked to stay an additional year, but he successfully completed that training there at Los Angeles County.
And by demoted, I mean he was initially hired as a proper pathologist, but then was essentially demoted to a fellow, which is essentially similar as a pathology student, correct?
No, he did a fellowship there in Los Angeles, just like I did the fellowship in forensic pathology in Atlanta.
In particular, when he was in California, and also when you hired him, you were familiar with the Dr. Louis Belfini case?
Yes.
That was essentially a case where a doctor was alleged to have strangled his wife or killed her.
No, what happened was that he found his wife dead. It was in the yard, and he said that she basically put her head in a bucket of water and committed suicide.
By what I mean as to a prosecution did take place initially in that case, did it not?
Well, what happened was that they initially looked at that and they accepted the doctor's statement. Dr. Gill did the autopsy. He found a lot of areas of injury on the face. It didn't look like something where she willfully stuck her head in a bucket of water and committed suicide. So he ended up with making an opinion that it was a homicide.
Specifically, I believe he noted it was a textbook case of suffocation.
I don't recall that.
From your understanding, when you hired him, he had claimed that the case had fallen apart due to prosecutorial misconduct.
Objection, relevance, Your Honor. I'm not sure where we're going with all this.
Sustained.
Your Honor, it goes. Can argue in your report if I may approach.
No.
Ask for a hearing.
No. Let's move on.
Eventually, prosecutors asked for him to resign, and you still stood
Objection,
by
Your
him
Honor.
after knowing all these issues.
I'm going to overrule that objection. Go ahead. You can go ahead and answer.
What the 6 area prosecutors did was they wrote me a letter and they asked me to not allow Dr. Gill to do any homicide autopsies on any of their cases. That wouldn't have been possible for me because a lot of times you don't even necessarily know if the case is a homicide or not when you do the case. And also it would basically have made me on call every day, 7 days a week. It would not have been something that I would have been able to sustain with only 2 doctors in the office.
Did you initiate looking for another pathologist to replace him and keep him working during that time period?
I don't think Dr. Gill did anything wrong. Okay. Yes, he did have an alcohol problem, He did take the physician diversion training in California. He successfully passed it. The very last time that he ever drank an alcoholic beverage was 1994. At the time he was under my supervision and hire, he did an excellent job. I think he was right in the Pelfini case. I didn't see any problem with Dr. Gill, and as such, I didn't see any reason to prevent him from doing what he needed to do. Now, I told these prosecutors that if you needed somebody to provide any kind of character witness in terms of his reliability and his work, I'd be more than happy to testify to that. But I couldn't accede to their demands that I prevent Dr. Gill from doing any autopsies, because that would not, well, it would be throwing a colleague under the bus, no good reason. He was clearly not under the influence of alcohol during any of the time that he was working in my office. We looked at him like a hawk. There's no problem with his performance. I think he was basically misjudged and mischaracterized by a lot of these media reports, including NPR. I think he's been treated unfairly. And I didn't see any reason to let him go or to look for somebody else.
Would you agree that a pathologist not taking any photographs during the autopsy is inappropriate?
Their situation, the police took all the photographs. And the police at that time didn't think that this was a foul play case, so they didn't take any photographs.
But a pathologist carrying out an autopsy should document every step they take for purposes of just verifying that they did things appropriately, correct?
Well, sure.
And they should do their best to photograph what they do and notate what they do correctly so that they don't misstate where a bruise is located on a person in their autopsy.
There wasn't any problem with his autopsy. Now, regarding the photographs, they had a situation where they had a multi-county arrangement, and the people who were responsible for doing all the photography were the police, both in the autopsy suite and at the scene. The police elected not to take the photographs, not Dr. Gill.
You're saying there was no issue with his autopsy in that case?
No.
Would it surprise you if the California bar found him to be incompetent in that case and having done a terrible job on that pathology report?
Well, they're not forensic pathologists, they're attorneys.
So you take no issue with the fact that he misstated where bruises were?
Objection, Your Honor, relevance.
Objection sustained, and we're going to move off the topic of Dr. Gill.
It's fine. Sir, let's talk about how you eventually ended up resigning from Jackson County Medical Examiner's Office. You noted during direct that you had had no founded or unfounded issues of essentially malfeasance or incompetence or anything along those lines, correct?
Correct.
And essentially that would lead into no findings of a lack of credibility.
I believe so.
Even unfounded, you said no.
Correct.
Now let's go to this Jessica Harper case. That was a case in 2005 that you became involved with. Are you familiar with that?
I'm familiar with the case, yes, sir.
And in that case, you were actually familiar with her mother.
I knew her mother, yes.
Her name was Elaine, correct?
Yes.
And Elaine worked for the Midwest Transplant Network, if I recall correctly.
Yes, sir.
And Elaine, back in 2005, you have previously noted in discussing that case in the past that she had told you that a defense pathologist had been hired on that case, correct?
Yes.
And that the defense pathologist agreed with the state pathologist in that case.
Correct.
And essentially the state pathologist and defense pathologist up to that point were noting that the injuries to the child's head were so severe that it seemed the top of the head was almost knocked out.
Right.
And you were not hired by Miss Elaine on the Harvard case, correct?
It's usually an attorney that hires me, not usually somebody who's not an attorney.
She or her attorneys did not pay you money to then testify in the Harvard case, correct?
In situations where I did work outside of duty hours, I could bill. I don't recall if I did or not in this particular case. But in a situation here where we're looking at it as basically during county time, and it was the county that billed for it.
Now, as far as your involvement in that case, it was a case out of Kansas State, correct? The Harbor case.
It was a situation here where the incident occurred in Lenexa, Kansas, okay, which is part of the Kansas City metropolitan area on the Kansas side of the state line. There was also some time where the child was in Chillicothe, Missouri. The biological parents were not living together at the time, but basically had the child in Chillicothe 1 week and then the child in Lenexa another week.
Harbor was not prosecuted in Missouri, right?
Kansas, Johnson County, Kansas.
And eventually, when you found out that the defense pathologist agreed with the state pathologist, you noted to Elaine that you would look at the case if she wanted you to.
Sure.
And then you eventually testified at a hearing in 2006, correct?
Yes, sir.
This was after Jessica Harbor had pled guilty to second-degree unintentional murder, correct?
She pled no contest.
Or she pled no contest, correct?
No contest.
And this was, your testimony was after that?
The hearing was on whether or not to remove the no contest plea and have the case go to trial.
Essentially allow her to withdraw her plea.
Her plea of no contest.
And at least as to testifying in that case, you did testify about using time at the Jackson County Medical Examiner's office to conduct your review, correct?
Sure.
You had actually your assistant, Dr. Thomas Gill, aid you in carrying out that autopsy review?
Yes, and also one other doctor.
And because the defense was not paying you, this was essentially partly on the dime of the Jackson County Medical Office, correct?
Well, Jackson County was getting paid for it.
Jackson County, Missouri was getting paid to conduct this autopsy?
Since we were using Jackson County resources and time, Jackson County was paid for the use of those resources and time.
And by that you mean the essentially taxpayers or the funds of the county would go to your office and that would then cover whatever time you used in the office?
Okay, Jackson County was making money on that. The taxpayers of Jackson County were making money on it.
You did not bill Harbor's defense team for this case at all, did you?
Jackson County bill.
Now, at least as to one of your chapters, do you not state that you should avoid doing any work that causes any resources to be used for any outside independent issues that aren't covered by the county?
Okay, and then in this situation, since Jackson County, we were using Jackson County resources and time, Jackson County was being reimbursed for that. There are all kinds of situations here where in civil cases or private or even potentially private matters where we've done autopsies or we've engaged in professional behavior where if basically Jackson County resources and time are being used, then Jackson County is able to bill for that. And that's what happened here. This is not a situation where I was making money using Jackson County resources. Jackson County was making the money. The taxpayer was making money.
Your supervisor was Catherine Shields, was she not?
Yes.
She had not given you any prior approval to carry this review out, had she?
Correct.
And actually, days later, after you testified, is when 6 different chief prosecutors asked you to resign. Is it not true?
Not true.
You're saying that they did not, under oath.
Under oath, I'm telling you that the letter that had to do with Dr. Gill did not even ask him to resign. They just didn't want him to do any hospital. They didn't want him to do any homicide autopsies. This basically occurred before the Jessica Harbor situation.
I'm not referencing the letter. I'm asking, after you testified in the Jessica Harbor case in the summer of 2006, didn't different prosecutors ask for you to resign?
Not to my knowledge.
You're saying that no prosecutors asked you to resign?
None.
And in fact, didn't one of those prosecutors then become the supervisor in 2007?
Okay, one of the prosecutors ran for Jackson County Executive, which basically would have made him the Chief Executive Officer for Jackson County. Okay, and he is Michael Sanders. He became the Jackson County Executive, and I elected not to work for him, so I resigned. Offered my resignation on December 1 of 2006. Gave him a month's notice.
So your testimony today is that you resigned in December 2006, but just because you didn't want to work for this prosecutor turned supervisor.
Correct, sir.
May I approach the witness?
You may.
May I approach him?
You may.
Show me the state of Tennessee, if you stood bearing it. Review page 21.
Yes, sir.
Isn't it correct that you resigned in 2006 as a result of 6 prosecutors noting complaints that they could not rely on your opinions?
Not correct. What you underlined in that case, which is a document that I think maybe an appellate court in Tennessee wrote, is a misstatement of fact.
You're claiming that this never came up in transcripts, that they relied on to make a decision.
They did not state what was true. That's not what happened.
So this appellate court essentially is wrong.
Yes.
Now, going to your discussions of Dr. Cavalier, you noted that you believe CPR could have caused further hemorrhages in Chloe, correct?
I don't know. It's unclear. On one hand, I'm forgetting his name.
Corey Bitch.
Okay, he said one thing in one place, he said another thing in another place. Exactly what happened on that, I don't know, so I can't say.
During the discussions of circulation during the resuscitation effort, you noted that, at least in one of the documents, it seemed to indicate some circulation was going on.
It might have. I don't know.
And so you don't know whether CPR would have caused any further hemorrhaging.
I don't know.
discussing with Corey Binge how he carried out that CPR would have allowed you to at least know the possibility of whether there was anything indicating that that hemorrhaging would take place.
I don't know.
You did not interview Corey Binge in any way, correct?
Correct.
And so you couldn't ask him about that possible difference between his report and the testimony you claim you reviewed.
Correct.
You noted that all hemorrhages are not specific for anything in your direct testimony, correct?
Okay, repeat the question.
At least hemorrhaging in the neck, it doesn't necessarily have to be specific of anything, correct? That's what you stated in direct or something to that effect?
Sometimes hemorrhages are an indication of specific trauma. And sometimes hemorrhages may be basically an artifact of autopsy. It can go either way.
I believe you at some point noted that they can occur in natural deaths.
Sure.
Now those natural deaths would be common in, say, a body that's decomposing or prone on the ground for a while.
Those are two examples, sure.
Another example would be folks with seizure disorders that would have that type of bleeding in the neck.
I don't know about that.
Prolonged resuscitations, would you agree that those would cause hemorrhaging in the neck?
I don't know about that.
There aren't really any other natural deaths where that type of hemorrhaging in the neck would be found, correct?
In many cases where I've autopsied somebody who has maybe like a sudden cardiac death where they suddenly died, and you do the autopsy, and they have this very, very purple face and neck and shoulders, it's not infrequent there to do an autopsy and find areas of hemorrhage in the neck, and even here areas of hemorrhage in the scalp, and the deep scalp tissues, even though there was no trauma.
You noted that you had never seen a child strangulation case, correct?
Correct.
That's because it's essentially a lot easier to smother a child.
Perhaps.
That would essentially be just because the child is weaker, smaller.
I don't know. Perhaps.
And that there's no child strangulation database, you agree with that?
Sure.
So maybe a pathologist that has seen these cases far more frequently versus you've never seen a child strangulation, their experience might inform their opinion differently than yours.
Maybe. I don't know.
I'm going to have a moment, Your Honor. Now, in a situation, this is just a hypothetical. It's a hypothetical. I think it's been posed before, though I like hypotheticals generally. You've seen cases, for instance, in smothering of a child situation, where there's no findings of the autopsy indicating one way or another what happened, but somebody did actually smother that child, correct?
Sure.
And the way you find that out is essentially the person confesses to doing it.
Sure.
Nothing further, Your Honor.
Redirect.
Thank you, Your Honor. Now, Dr. Young, just kind of going back through some of the things that the state had discussed with you during your cross-examination. The majority of your consultation work does, in fact, come with criminal defense attorneys, correct?
In criminal cases, yes.
Okay. In criminal cases, the state has their own medical examiner and wouldn't necessarily have a need to hire an independent medical examiner. Would you agree with that?
I would agree with that.
You were asked questions about a book that you wrote regarding the things that you should do as a medical examiner, right? 22 rules, I believe, correct?
Correct.
And anywhere in that book, does it tell you that you should compromise your ethics in order to get paid?
No, sir.
And not only are you board certified, you also served as a member of the military for this country, correct?
Yes, sir.
Has there ever been a circumstance in your career where you felt compelled by money to compromise your ethics?
Objection,
No, sir.
bolstering.
Sustained bleeding.
Dr. Young, has there ever been a circumstance where you compromised your ethics for money?
No, sir.
Now, if the jury had heard Dr. Cavalier testify earlier that when a person is asphyxiated, they're generally going, or I'm sorry, let me strike that. When the carotid arteries are impinged, a person can lose consciousness between 3 and 15 seconds. Is that square with your understanding?
Yes, sir.
And you don't disagree with that, do you?
I don't disagree with that.
Ultimately, if that observation led to her opinion that there would not be any thrashing around, do you agree with that opinion?
Okay, I don't understand. Where's the thrashing come from?
Let me rephrase, Dr. Young, just so the jury is clear. Your contention with Dr. Cavalier isn't that a person is going to lose consciousness in 3 to 15 seconds if their carotid arteries are compromised. You don't take issue with that, correct?
Okay, in a situation where you completely cut off the arterial circulation to the head and you keep it closed off, then you can lose consciousness very, very quickly. What often happens, however, in a strangulation case is that there's a big struggle that takes place, and there are efforts to close those vessels, and then there are also efforts to keep them open. And it's often, frequently during a struggle, that it doesn't seem to fit that kind of clean-cut laboratory situation where an animal will basically lose consciousness in 3 to 15 seconds. Okay, a strangulation is a situation where there's a violent struggle going on, and 2 people are playing a role in it.
Under any circumstance, prior to losing consciousness, in between 3 and 15 seconds, would you expect somebody, if they were fighting to their lives, to struggle in some manner before losing consciousness?
Okay, in a strangulation scenario, you mean?
In any asphyxiation scenario, prior to that person losing consciousness, assuming they don't want to die, would you assume that person would struggle before losing consciousness?
Okay, I don't understand your question. I'm sorry.
Let me strike that. During your cross-examination, doctor, you were asked about some of the literature indicating that there may, in fact, not be marks on the skin in certain scenarios that were presented. Do you recall that
Yes,
question?
sir. Yes, sir.
Does may mean that there will never be any marks on the skin in those circumstances?
It's not an all or never sort of thing. Whether or not there are marks frequently happen in a strangulation setting with how much of a struggle is put up. If you're dealing with an infant that is 3 months old, they're not going to really be able to struggle all that much if the mouth and if the child is being smothered. And so you don't see typically those kinds of things. On the other hand, if you have an older person and there's an attempted strangulation, there is a very violent and vigorous struggle. And with the struggle comes the injuries.
Okay. Now, it's been pointed out, and I believe the state ultimate point here is that this is only a 5-year-old child. How much struggle are you going to expect from a 5-year-old child?
Oh, I think a 5-year-old child can struggle very vigorously. Consider what it would take if you had a cat and you decided to give the cat a bath. Don't you think the cat, especially one that's not used to taking a bath, wouldn't that struggle? And what if you tried to strangle the cat? Now you could basically overcome the strength of the cat. That doesn't mean that you're not going to get scratched up along the way. And certainly a 5-year-old child is completely capable of doing that if they're being strangled.
Now, during your cross-examination, it was pointed out to you that you've only seen one of these types of cases, and apparently Dr. Cavalier has seen lots and lots more of these types of cases. Did you understand that questioning?
I remember the questioning.
If Dr. Cavalier testified that she's personally participated in 23 of these types of cases, does that seem credible to you?
Objection, Your Honor. Prior motion eliminates section 9.
Sustained.
In your experience, Dr. Young, you were the chief medical examiner for how many years in Kansas City?
11 and a half years.
And prior to that, you were an associate medical examiner in Atlanta, Georgia?
Yes, sir.
For how long?
7 years.
And in all of that time, you only had one child hanging death that you can recall, is that correct?
I think there may have been more than one. Maybe about 3 or 4.
Would a number like 23 be extraordinary?
Objection, Your Honor. Same.
Sustained.
Well, I...
Objection.
Sustained.
I'm sorry.
Respond.
Excuse me.
Okay. And so, Doctor, you've talked a lot about the injuries that you would expect to see in a strangulation death. Knowing that this case was initially reported as a hanging death, do you see any consistencies with a hanging death? Or, I'm sorry, with a strangulation death, I should say.
The case is not consistent with the strangulation.
And why is that again?
Because of strangulation, you see a whole different set of findings than you would in this case. You'd see evidence of a struggle. You'll frequently see evidence of head injury. You'll see petechial hemorrhages in the face and in the linings of the eyes. You'll see hemorrhages in association with broken bones and cartilages in the neck.
And if we can just distinguish, why in strangulation deaths what's the relationship between the hemorrhages in the neck and the strangulation death that you would typically see? Why do you see hemorrhages there?
Well, what is thought to happen there is that it's frequently related to trauma. Okay, there was one point that it was thought to be due to the lack of oxygen, but that's thought to be less and less the case. Part of it is basically the struggle, and you can see petechial hemorrhages in a situation where there's trauma. And strangulation deaths are very traumatic deaths.
Would it be your expectation in a strangulation death to find hemorrhages consistent with the location of, for instance, the thyroid bones fracture and the other cartilage fractures that you would typically see in a strangulation?
Usually if you see fractures in cartilages or the bones in the neck, when you're seeing hemorrhages in association with those fractures, it means that there's still circulating blood, as opposed to a post-mortem situation where there's a break from perhaps handling the body and no bleeding whatsoever.
And what if you see hemorrhages in the neck, but you don't see the corresponding fractures or breaks?
As I've mentioned before, that kind of finding is non-specific. You can even see areas of hemorrhage in natural deaths.
And even when Dr. Cavalier is testifying about deep tissue hemorrhages, again, that would be non-specific, a non-specific finding?
Yes, particularly if they're in the posterior compartments of the neck, in front of the spine, where you have a large collection of veins. It's not uncommon in an autopsy to see basically artifactual extravasations of blood, especially in those areas. And that's part of the areas that she's describing in her autopsy where to see hemorrhage.
In your opinion, based on your review, is Kelsie Thomas's description of what had happened consistent with the findings that you observed?
Objection asked and answered.
Sustained.
And Dr. Young, just one last topic to discuss with you, just briefly regarding your credentials. There's a lot of discussion about one of your colleagues in Kansas City, Dr. Gill, correct?
Yes, sir.
Now, you personally, you didn't have any problems with alcohol or anything else that related to Dr. Gill, correct?
Correct.
And as you were his colleague, you were aware of potentially some issues with Dr. Gill, but those were monitored, and you didn't have any issue with the job that he did as a forensic pathologist, correct?
Correct.
Now, as I understand, there were prosecuting attorneys who had an issue with Dr. Gill. Is that correct?
Yes, sir.
And based on those issues, requested that he not participate in homicide investigations. Is that how I understood it?
Yes, sir.
Practically speaking, that just was not going to work out for your office, was it?
Correct.
In addition, you felt like you'd be throwing a colleague under the bus. Is that true?
Yes, sir.
The state is couching this in a way that you were forced to resign from your position. Were you forced to resign from your position?
No, sir.
Did anyone at any time ask you to resign your position?
No, sir.
Would it be fair to say that in any appointed job there are some politics sometimes that people don't want to be involved in?
Okay. That don't want to be involved in?
Well, here, let me ask you this way. Ultimately, you resigned because you did not want to work for who was going to become your new executive supervisor. Is that correct?
Right.
And when I asked you earlier, have you ever been censured or ever had anything done to you based on any unethical behavior or anything that you've done since you become a forensic pathologist, your answer was no, correct?
That was my answer.
And that is still true despite every question that the state asked you, correct?
Pleading, argumentative.
Sustained.
That is still true, correct?
Yes.
I have no further questions, Your Honor.
Recross.
Your Honor, I pass the witness, no questions.
Anything else for this witness?
No, Your Honor.
You may sit down. May this witness be excused.
Okay.
You may also be excused and leave the courtroom if you choose to do so.
Thank you.
Does the defense have further evidence available this morning?
Your Honor, we've made arrangements for our next witness to begin at 1 o'clock. I can get him here sooner, but there would be a delay attendant to that as well. We're at 11:30. It might be appropriate just to take our lunch break now.
Okay. If I let them go till 12:45, do you think you can get your witness here?
I believe so.
Okay. So, members of the jury, we're going to take a lunch break. Please remember all the prior admonitions. Keep an open mind. Don't talk to anyone about this case. Pay no attention to immediate counts. No investigation. Be back in the jury.